Hello everyone and welcome to the November 2024 episode of My PIP Monthly. As always, this is Amber Rouse Holloway, an executive partner here at our Troy office. Now our November 2024 topics include a case law discussion. Here we'll discuss the case of Peyton v. Mimic and Willie King. And this was issued a couple years ago on July 28, 2022 and is an unpublished opinion. Then moving on to trending topics in PIP litigation, which will be the larger section of today's episode, where we will talk about issues surrounding the Michigan Assigned Claims Plan, including the cases of Bakeman v. Citizens and Great Lakes Pain and Injury Chiropractic Center v. Farm Bureau. Now, first up in our case law discussion, we have the case of Peyton v. Mimic Insurance Company and Willie King, again unpublished but issued on July 28, 2022. Now this case in the trial court, Mimic did move for summary disposition, ultimately arguing that the vehicle operated by plaintiff at the time of the accident was not covered under the subject policy. Now the trial court denied Mimic's motion and granted summary disposition to Peyton ultimately. Now, just a brief background on this one. This was a 2018 accident where co-defendant King was riding his bicycle when Peyton, who was operating a Chrysler Pacifica, crashed into him. Now, Peyton failed to list the Chrysler Pacifica on the deck page of his Mimic insurance policy, and following the collision, Willie King filed suit against Peyton and Mimic, seeking first and third party benefits. Now, Mimic provided Mr. King with personal protection benefits. However, Mimic did not provide bodily injury liability coverage because Peyton's insurance policy did not contain bodily injury liability coverage. Now, it didn't contain it only for the Chrysler Pacifica. Now, Peyton consequently filed the deck action against the policy because filed a deck action against Mimic, arguing that the Chrysler Pacifica was covered under his insurance because it was a replacement vehicle or substitute vehicle, in which the court thereafter consolidated the cases, and then this motion for summary disposition came after. Now, ultimately here, Mimic initially argued that the Chrysler Pacifica was not a covered vehicle under the policy, and thus Mimic was not required to supply bodily injury liability coverage, and the court did agree. Now, the court relied on the case of Auto Owners Insurance Co. v. Harrington and followed this two-step approach. Now, this approach first required a determination of coverage according to the general insurance agreement, and second, a decision regarding whether the exclusion applies to bodily injury coverage to an insured car. Now, under the policy here, an insured car means Peyton's car as described in the deck page, a replacement car, a temporary substitution car, an additional car, and a trailer owned by Peyton. Now, it's worth noting that Peyton's policy excluded coverage if he was using a vehicle that was owned, leased for 31 days or more, or furnished or available for frequent regular use by Peyton or any resident relative, unless it was described in the deck page, or it was a replacement vehicle, a temporary substitute vehicle. Now, in making their argument, Mimic asserted that there was no coverage under the general insurance agreement and that the exclusion applies, negating coverage here. Mimic relied on the plain language of the policy, which provided coverage only for damages arising out of the use of an insured car. The Chrysler Pacifica was undisputedly owned by Peyton and was absent from the deck page, so that is very important to note. Thus, according to Mimic, the Chrysler Pacifica could only be covered and not excluded if the vehicle was a replacement car, a temporary substitute car, or an additional car. However, as the court determined here, the Chrysler Pacifica did not fit the definition of any of those things, i.e. it was not a replacement car or a temporary car or a trailer, because Peyton owned the vehicle. Further, Payton failed to notify MEMIC of the purchase of the Chrysler Pacifica within 30 days of acquisition, and therefore it could not be defined as an additional car or an insured car. Now, in rebutting MEMIC's argument, Payton did argue that MEMIC's claim log indicated that Payton, my apologies, was the owner of that vehicle, and that his policy was in effect at the time of the crash, but ultimately Payton did not add the vehicle, did not tell MEMIC that it was a substitute car, and the facts also show that it wasn't an additional car or a substitute car. But here, ultimately, the court turned their opinion and reasoning on the plain language of the policy, and that the vehicle was not a covered automobile policy under the specific terms of this policy. And as a result, MEMIC was not obligated to provide bodily injury coverage for the third-party claim only. All right, moving on to trending topics and PIP litigation. Here I wanted to discuss some issues surrounding the Michigan Assigned Claims Plan, or the MACP, which is generally speaking governed by MCL 500, 3172, 73, 74, and 75. Now, generally speaking, MCL 500, 3172 covers the conditions. 73 discusses disqualified individuals and eligibility. 74 discusses notice and how to provide notice to the MACP, and then 3175 governs or is regarding the rules governing the assigned claims plan as a whole. Now, I specifically want to highlight these two cases. First, we're going to discuss the case of Bakeman v. Citizens Insurance Company of the Midwest, which is an unpublished opinion, this is a published opinion from 2022. Now here, entitlements through the MAIPF, again, is governed by MCL 500, 3173A, where a person commits a fraudulent act when, 1, the person presents or causes to be presented an oral or written statement. That statement is in part or in support of their claim of no-fault benefits. 3, the claim for benefits was submitted to the MAIPF, and further, the person must have known that that statement was false, and 5, the statement concerned a fact that was material to the claim. And again, this specific section, 500 3173A, is talking about how to become, or how an individual is disqualified from receiving PIP benefits under the assigned claims plan. Now, under the case of Bakeman v. Citizens, the court discussed that it's now well established that self-conflicting testimony does not allow a party to manufacture a question of material fact, and that courts should not presume that either of two arguable contradictory statements is the true one. There should be a case-by-case approach in analyzing these inconsistent deposition testimony or inconsistent statements, as adopted, generally speaking, by the Michigan Court of Appeals, which we see in a lot of precedented cases. Now, in this case specifically, the court needed a careful review of plaintiff's self-conflicting deposition testimony, and that's the only way that it could be resolved to determine if there was a false statement or fraudulent act when applying for benefits from the assigned claims plan. Now, conversely, this next case deals with the statute and how the MAIPF cannot deny a provider's claim due to a claimant's refusal to cooperate, which is difficult because, as we know, insurers such as MEMIC, as we talked about earlier, insurers, any insurer, Farm Bureau, MEMIC, State Auto, they can deny a claim based on their insured's non-cooperation. That is when an insured doesn't go for an IME, or an insured doesn't forward a complaint when they receive it. Those situations, maybe not on their own, but in combination of other things or continuous things like that, can protect a provider or protect an insurer when they deny benefits. But it's not necessarily the case with the MAIPF. According to the case of Great Lakes Pain and Injury Co. v. Farm Bureau, the MAIPF can only suspend benefits until cooperation is resumed, and they cannot deny benefits for the undiscoverable future. Now, this case specifically talks about MCL 500-3173A, which is a hot topic with these cases because it, like I said earlier, and in the other case, it talks about the disqualification from the MAIPF or MACP and the eligibility that entitles a claimant to benefits from the claims plan. And some things that'll get you kicked out of the claims plan immediately are providing a false statement, not providing notice, things like that. But still, the claims plan, specifically with regard to non-cooperation of a claimant, can only suspend benefits and not deny them pursuant to this case, although unpublished. Now, the case talks about how the statute language and this ruling here make it necessary for the placement facility to establish non-cooperation as soon as possible after the claim is filed. And that's just to protect the plan itself. And that means the adjusters must document it as soon as possible that this claimant is not cooperating for whatever reason. But it seems to be from the facts specific to this case, which I don't really feel the need to get into, but there needs to be multiple instances of non-cooperation and not just, this person didn't respond to one letter for the claims plan to suspend benefits. And ultimately, that is all I have for you guys today. As always, thank you for listening. Please feel free to reach out with any comments or concerns. Thank you.